I'll call this meeting to order while everyone is paying rapt attention. Welcome to meeting number 66 of the House of Commons Standing Committee on Government Operations and Estimates, pursuant to the order of reference adopted by the House on Wednesday, February 15, 2023, and the motion adopted by the committee on Monday, May 1, 2023. The committee is meeting for clause-by-clause consideration of Bill C-290, an act to amend the Public Servants Disclosure Protection Act. We have a couple of irregular witnesses today. It is Ms. LaRoche and Ms. Stevens. They are here just to answer questions. They won't be making any opening statements. With us today, in place of our analysts, we have legislative experts who will be relying on quite heavily today, I suspect. It's Ms. Sauvé closest to me and Ms. Boyer furthest from me. Now, colleagues, this is actually in my almost 8 years, will be only the second time we've actually done a clause-by-clause in OGGO. So I hope you will all bear with me, and I hope we'll all bear with each other on this as we go through it. I do have a small opening statement prepared by our ledge assistants that I will just read. It's just general information on the clause-by-clause today. So I'd like to provide members of the committee with some instructions on a few comments on how the committee will proceed with the clause-by-clause on 290. This bill, as we know, is an examination of today's examination of all the clauses in the order which they appear in the bill, except for the short title, which will be considered at the end. I will call each clause successively and each clause and subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. If we're all in general agreement, we will just do it on division, if that is fine with everyone. Amendments will be considered in the order in which they appear in the bill and the package each member has received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. In addition to having them properly drafted in a legal sense, amendments must also be procedurally admissible. I may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it was agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. And we must not offend the Crown. If members wish to eliminate a clause of the bill altogether, the proper course of action is to vote against the clause when the time comes, not to propose an amendment or to delete it. I'm going to go very slowly so all members can follow proceedings properly. I will mostly be going slowly for my own benefit. In the package that was distributed by the clerk of the committee, amendments have been given an alphanumeric number in the top right corner to indicate which party submitted them. There's no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During the debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and the sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved on, or the committee may consider the main amendment and vote on it, just to keep things interesting. Once every clause has been voted on, the committee will vote on the short title, the title of the bill itself, and in order to reprint the bill may be required if amendments are adopted, so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments as well as an indication of any deleted clauses. Before we start, I'm going to turn things over to Ms. Sauvé for just a couple quick comments about some changes. Ms. Sauvé?
Thank you, Mr. Chair. As members will have noticed, a number of new amendments, 12 new amendments, were distributed shortly before the meeting started, so we unfortunately did not have the time to include them in the package in the proper order. I have advised the chair of when these amendments will be coming up in the course of the clause-by-clause consideration, which order they should be considered in. So there may be some short delays as we wrap our heads around the new order of things. So, thank you.
Thank you. And again, I just ask for everyone's patience. I'm sure there's going to be a lot of back and forth, and it's a rather irregular for our committee business. So we'll start pursuant to Standing Order 75-1, consideration of Clause 1. The short title is postponed. I will call Clause 2. So shall Clause 2 carry? I see Mr. Fergus. On Clause 2 or on the title? Please tell me Clause 2.
Good. I just want to thank you and thank all members for their patience. Particularly, j'aimerais remercier M. Garon pour le travail qu'on avait fait, la collaboration. Et j'aimerais remercier tous les membres. Oh, désolé. Alors, j'aimerais tout d'abord vous remercier.
First of all, are you okay? So, for the third time, I hope the third time's a charm, I would like to thank you, Chair, and all members of the committee, especially Mr. Garon. This is a bill coming from, it's a very important private member's bill, and I hope that we will be able to pass this bill in an acceptable fashion for all members. I thank everyone who has submitted proposals here, and I'll have a lot to say during our discussions, but I just, first of all, want to assure my colleagues of the government's good faith to ensure that we can move forward in many ways to protect people in the public service. Thank you.
Thank you, Mr. Fergus. Shall Clause 2 carry? On division? On division. Clause 3, which is a block amendment. Do you wish to speak on it, Ms. Vinola?
Donc, en effet, pour l'article.
Yes, so for Clause 3, we have an amendment that you received last week. This amendment helps define what is political interference that can be identified in some parts of government. So we say political interference means interference in the public sector in a way that causes any political, personal interest, etc. So this is just to make sure that public good will supersede any other interest, whether it's personal or political. I want to now give the floor to my colleague, Mr. Garon, who is the one who submitted this bill.
Oui, je suis prêt, Monsieur le Président.
I am ready to speak, Mr. Chairman. I'm glad that my colleague was so kind to give me the floor. Well, this bill is very important to me. This amendment really wants to define what is political interference. So here we have a definition under Article Clause 4 that is clear and that is legislated, and that is in line with what is done elsewhere, like in the United States when we talk about political interference. So, well, there are many approaches that are recommended and many possible approaches in this respect. The first would be what was defended by the many witnesses and experts who came before us, including those from the Government Accountability Project. They recommended to include a definition in the law. The second, in more conservative amendments, is to leave the government that initiative to define that through regulations. And we, and experts think that that is a modus operandi or a mode of functioning that might weaken this bill. And I've just been informed, Mr. Chairman, that in the list of amendments that were tabled by the Liberal Party, that there is an amendment that proposes to simply withdraw this definition altogether. So I think that it should be in the law, that it should be clear, and that it should be in line with the standards that we find everywhere else. And that is the raison d'etre of this amendment.
Mr. Garon again for putting forward this BQ1 and this amendment. I think this amendment, it's very important that we understand that to define political interference, we have an opportunity. Je pense qu'il veut. Ferme ton micro, excuse-moi. To define political interference, the best way to do it, we feel, is in the Conflict of Interest Act, because there are provisions in there. So, although I would recommend that we don't vote for BQ1, but we do support what will be coming up afterwards, which gives us a political definition that we have in what would be, I think you've received a clause on the table drop version on page 2. Did I get that right? Sorry.
Mr. Varela?
Serait possible d'avoir, de faire distribuer.
Could we have paper copies of the proposed amendments to date so that we can work smoothly? It would make our work, ultimately, we would surely gain more or catch up on time.
Right now, so there's just what was emailed out at, I think, 2:53 p.m. Speaking right to, no one wants to speak, right to. No one wants to speak, go right to. Okay. Ms. Kusi?
Sure. So then, is the government proposing another definition of political interference, or just standing in opposition of or concern to this? Okay, that's yeah.
So the definition which we'd like to use is the one that's in the Conflict of Interest Act that
Okay.
already exists. It's well referred to, and it's one that stands the test of time.
That's not located within the new amendments that just arrived from you, I believe, because they start in clause 4. So I don't think so. Okay.
And it has a reference number at the very, very top, which ends with the numbers 471, 471. And it
Okay.
says,
Yeah. I see. Okay.
you okay with that?
Colleagues, are we ready to vote, or
Thank
do you wish to
you.
wait a few minutes to read?
I have this.
Ms. Vinola? Ms. Kusi?
OK. Oui, je vais demander un bloc.
I'm going to ask Bloc Québécois why they thought it was necessary to propose amendments after proposing a private member's bill, because normally when we're drafting a bill, we would include everything that we want to see. I can see that you have several amendments here. Was it inspired from the testimonies that you received? What inspired this?
Just going to interrupt. I'm sorry. I realize there's been a lot of paper dropped at the last second, unfortunately, and we're just getting it now. But to ensure smooth sailing, I will just follow. If there's no other speakers, I will call a vote. Don't take it as I'm pushing you, but just so we have clarity, I will do that. If you do wish to speak on it then please raise your hand. Mr. Garon?
Merci, Monsieur le Président.
Thank you, Chair. First, I'd like you to understand that well in our process, we underscored the importance of listening to witnesses first. And given the fact that Canada is a bit late on whistleblowers, an initiative that is more developed abroad, especially among jurists who developed this in parallel, ensuring that we have a better regime to protect whistleblowers. This is why we insisted on receiving them and listening to them. And we thought it was obvious to us to inspire ourselves from this testimony, especially with the fact that it was possible with the private members' bill to introduce those. Yes, the bill had the broad outlines of an enhanced program, and it would, with some amendments, including those that we're presenting, would surely ensure that Canada is one of the best places where we do tick at least 8 of the criteria of protecting whistleblowers. So when we have witnesses, we listen to them and we study and negotiate and integrate their recommendations. And I've had a lot of discussions with my colleague, Mr. Ferguson, so that's why you see these recommendations or these proposed amendments. Now, on this specific amendment, we deemed it important, and the witnesses did as well, and it has been done abroad as well. We thought it was important to clearly define political interference. We thought it was clear that it is necessary that it be legislated. Now, under the law on conflict of interest, we know that it only covers those who are in public, who have government responsibility or in public service. We thought that this law needs to be coherent and should be implemented throughout the chain of command, permit that term, throughout the chain of hierarchy. And this is why, once again, we recommend this amendment that we are submitting here. I just want to assure my colleague, my honorable colleague, that we don't want to limit the scope of the law on whistleblowers, but we want to rely on an already existing definition, a definition that exists in the plethora of laws that we have in Canada, and we would like to use the same definition that already exists instead of creating a second definition that may not have the advantage of already existing over time. Yes, I had discussions with colleagues, and those were constructive discussions. But when a definition is developed, we develop this definition that will be implemented on people who have specific responsibilities in specific contexts. This is why we relied on experts. In the law on conflict of interest, I'm not saying, in the Conflict of Interest Acts, I'm not saying that I reject that definition, but in the Conflict of Interest Act, that definition was written in such a manner that it would be covering those who are in public service or who have public responsibilities. This is why we reviewed this definition, and we thought that this definition is rigorous, coherent, exhaustive, without going beyond its scope. So I am a bit hesitant to say that in all of this legislative corpus, we cannot have two definitions that cover two different things. I did not fully read the amendment, but I know that we are talking about political interference, which means interference in the public sector in a way that causes any political or personal interest to prevail over the public interest, including by influencing or directing a public servant. So we also are talking about to exercise a discretion or a power, or to refuse or fail to do so, or to take any other measures. And in B, what we talk about in any other way that does not observe the distinction between political and personal interest and the public interest or the priority of the public sector of the public interest. So I want to know in this definition, beyond the explanation that there will be two definitions, what is unpleasant about this definition? If someone can explain that.
Mr. Fergus?
Encore une fois, Monsieur le Président, I guess my be in several parts in his definition that he has invented for this purpose, as opposed to relying upon already well-traveled and understood principles in existing legislation. There's a number, I mentioned what, 1, 2, 3 times, 4 times. What is public interest then in terms of that definition? So I think this is why when we start getting into the weeds of this, it's much better if we can to stick to existing legislation where we know what the definitions are, as opposed to inventing something new, because then I think that will lead us down the garden path in a sense.
Could you move your mic a bit closer to yourself, or move the mic over to you?
Absolutely. Happy to do so.
Ah, wonderful. Thank you, Mr. Fergus. Mr. Guérin?
Outre le fait que je pense qu'on
Apart from the fact that I think that we can already vote on this proposed amendment, the current definition of a reprehensible act includes the violation of an existing law, including the Conflict of Interest Act. So now we have two liberal amendments. The first one that recommends the withdrawal of the notion of political interference. And we know that that will weaken the impact of this bill. And we have a second liberal amendment which includes the Public of Interest Act. So what this amendment that we're proposing is doing is simply to enrich the bill. It enriches everything that already exists in our corpus regarding conflict of interest or interference. In any case, I think I'm ready to vote right now, Mr. Chairman.
Colleagues? Shall BQ1 carry then? On division, do we need a...
Because I really want this to be a collaborative spirit, but I really do think that we'll be creating a difficulty here, Mr. Chair, in terms of the definitions by adding a new legal definition. So I'm not certain where we're going to be getting to the point where Mr. Garon truly wants to get to. I don't know if there's an opportunity that we can have by asking a question of our officials from TBS or asking our officials.
They're not, at this point, offering anything, but perhaps our witnesses could weigh in. And this is specifically on having this motion passed with one definition with a to-be-discussed later amendment, but not necessarily a changed one from the Liberal amendment.
Could you please repeat that? I'm sorry. So only BQ1 and not, I'm sorry.
Well, Mr. Fergus is asking about, if I go ahead, Mr. Fergus, but I believe what the question is if we have one definition here under BQ1, does it conflict with another definition of another amendment that hasn't passed yet later in the bill? Unless, Mr. Fergus, you wish to clarify?
Sure. I guess the question which I would ask is this: is it better to use an accepted definition for the purposes of coming to an understanding of what political interference is, as opposed to inventing a new definition?
Well, I will leave that decision to the committee in terms of deciding.
Just please.
Je vais laisser la décision.
Well, I'll leave the decision to the committee about introducing this definition or not, but there are many definitions. When you can talk about the Conflict of Interest Act, but there's also a law in the public sector that has a definition in this respect. So depending on the use of the different laws, there could be a scope that needs to be understood, a scope of jurisdiction, and also it's important that terms be clearly defined so that the general administrator or whoever would be in charge in the different departments would be able to implement this in a tangible manner. In that way, we can make sure that we have a definition that is implementable and that really meets the targets that we have set. That would be my commentary. Thank you.
Other than Mr. Garon? Well, maybe we'll go to Mr. Garon if Mr. Housefather's not able to hear us.
I hear you. I can hear you, Mr. Chair.
You have your hand up.
Yes, I thought you called Mr. Garon.
No, I called you, then Mr. Garon. So go ahead, Mr. Housefather.
Thank you. I just wanted to understand from the witnesses. My understanding is political interference probably should be left to be defined by regulation because we have to make sure it's both consistent and objective. And there's one part of this definition that I find quite troubling. For example, if you look at little one or little I, to apply a law not according to the intention of Parliament, but according to some other interpretation preferred by the person so influencing or directing, I would think that is incredibly subjective. There are probably 10 people who would offer 10 different interpretations of what Parliament intended laws to mean sometimes. And that becomes the subject of all kinds of litigation. Do you believe that this is an objective component of a definition if you look at little I, or would we be best advised to do what I think a further conservative amendment does, which is define this by regulation and think it through and have an objective definition consistent with other laws?
Thank you for your question. Just building upon the previous response that I gave, in order to be a practical or a functionable, une définition qui est fonctionnelle.
So to have a
means. And so I will have to agree that there is some definitions and even interpretation in terms at times of different laws and practices of what is the intent behind certain policies and programs. The advantage of doing a regulation is twofold, is in the sense that it allows to have a further elaboration on that, and it also allows for consultation where people could actually comment on that to make sure that it meets the intended outcome that Parliament would be seeking.
Mr. Garon, then Mr. Fergus.
Peut-être une question pour les experts.
maybe a question to the experts who are here with us today. In the framework of other laws, do we make reference to the intent of the legislator and that maybe administrative courts, if we want to give this law a chance to be fully operational, can we leave that the opportunity to administrative courts to rule on that? Well, to explain myself better, in a law or regulation, I believe that it has happened in the past that courts, administrative courts, and others have made rulings on the intent of the lawmakers. So I want to confirm if this happens. And also, there are definitions on the law on the public sector. There are several definitions that are not very clear, but I want to remind my honorable colleagues, with all due respect to my colleague, Honorable Fergus, that definitions don't necessarily make things incredibly more precise, especially with respect to the Public Service Act. We know that we have had to see more precise clarifications requested over time. Well, I'm not a lawyer by training, so I might not really be able to answer very accurately on that. We know that courts have to interpret and implement the law, and they respect the spirit that the lawmaker introduced in the law.
Perhaps a compromise solution I'd be interested in hearing from my colleagues across the table, would be looking at CPC 1 then, because CPC 1 then would amend Clause 3, but will allow for for regulations to for this to be prescribed to ensure that we can get that going. I'm wondering if that might be the solution there.
I'll just interject. CPC 1 will not move forward if NDP 3 or NDP 4 go forward. So those two have to be voted on first before we even get to CPC 1 and G3, sorry. Yeah, CPC 3, we do not have the same line issues with CPC 1. So, Mr. Garand?
Juste, si je peux me permettre,
If I may, and this is a message to my colleagues, my conservative colleagues, who in the amendment highlighted the importance of introducing a definition. Their methodology is different, but they underscored the importance of having a definition. Our definition is more in line with what the witnesses told us. So I'm trying to think about this, and we hear that to define clearly in a law what is political interference is problematic, is going to create all sorts of conflicts across all sorts of laws, and then we hear, and I'm not attacking anyone, I'm just trying to get some logic out here. We hear now that there are different definitions. There's no problem as long as it's the government that writes it out.
Yeah.
That's not exactly what I'm proposing. I'm saying that the definition, I believe the definition is problematic, but we understand that we need to have a definition of political interference. I believe that the best way to go about it is not to adopt BQ1, but if we want to go deep into the matter and ensure that the regulations are coherent, then we have the advantage of CPC 3 that gives us an opportunity to ensure that a definition would be proposed, one that is flexible and that makes sure that we would not create unnecessary conflicts or contradictory conflicts inside a bill that we want to adopt or enact.
je comprends.
I understand what you're saying. So what you're saying is that if we go to CPC 3, for us to go to CPC 3, you would like to withdraw these two amendments that you tabled. Is that what you're saying? For us to save time. They are not numbered, so I'm just ad-libbing here. The first one says that Bill C-290 Clause 3 be amended by deleting line 36 on page 2. And the second one that says that Bill C-290 be amended by adding after line 2 on page 2 the following. Paragraph C of the definition protected disclosure in subsection 2.1 of the Act is replaced by the following, etc. So are you ready to withdraw this amendment if we delete BQ1 so that we can study CPC 3? Fergus, I think that...
Ms. Cusi?
Je viens de dire à mon collègue du Bloc.
I just told my colleague from Bloc Québécois that it's best to have something rather than nothing. However, I would say that we can withdraw the first one. But the second one, if we look at the reference number, the reference number ending with 8922, if CPC3 is adopted alongside this clause, I think it will work.
Sorry, Ms. Casey.
Pas de problème. Oui, en fait, ça c'était...
No problem. I think that the objective of our amendment is to have the most flexibility possible, but of course to keep the spirit of the bill intact. Thank you. I won't lie that I prefer BQ1. And what I would prefer even more is a consensus. I think this bill is quite important that we need to be all in agreement. I really think that. Now, I don't have the same reference numbers as you, but when we look at these amendments proposed, the one that you are saying that should be preserved, let me read the text. It's just a few words. It'd be easier to read it out. That bill C290 in clause 4 be amended by deleting line 36 on page 2. And what BQ is saying is that what CPC3 is saying is that should be implemented, or the definition should be done through regulation. So what I would propose is that the Liberal Party withdraw these two amendments, that we drop BQ1 and then we discuss on CPC3 so that the government can have a definition which might be identical or different from what is in the Conflict of Interest Act.
Il y en a-tu une? Non.
All right, colleagues, just so we can stay kind of on top of things, I realize we can be pretty casual on OGGO going back and forth, especially discussion time, but just put your hand up, just be on the safe side. But Mr. Fergus?
Just making sure that I'm not going to be inventing rules, but I just want to make sure that if the officials felt that if we were to withdraw BQ1, and do you require what is reference number 8922? Or maybe I'll just wait a second here. No problem.
Je m'excuse. Pouvez-vous répéter? Je m'excuse.
J'aimerais juste savoir si je peux retirer.
I want to know if we withdraw BQ1 and
Referring to not any of the new amendments when you're discussing this with the officials, right? Because they will not have the new amendments.
I'm not certain if I understand the question. I'm sorry.
The ones that were tabled just today, I don't think they've got a copy. You're not referring to those, are you?
I was referring partially to those. I believe they have a copy.
I apologize. Where did you get the copies from? Because they haven't been moved, you shouldn't have copies of them yet.
I just gave them a copy. My
Fergus.
apologies.
All of your amendments, or the whole package, or?
I just gave them my amendments.
It's fine then.
Was that not
Please.
proper? I'm sorry.
No, but go ahead. Do you have a specific question? Then we can see if we can move on.
Sure. One with reference 89. Sorry, through you, Mr. Chair. Through you, Mr. Chair. Through reference number 8922, if that were to be combined with removal of BQ1 and added and worked out with the adoption of CPC 3, would that allow us to have the intentions known of what we want to have defined, and B, allow the opportunity to make sure that is consistent with other notions of what interference is?
The question?
Can you speak a bit closer to your mic?
Yes, just one moment.
We don't have the greatest sound today, apparently.
Okay. Is this better? All right. So thank you for the question. The amendment 8922 aims to remove the political inference as wrongdoing. The issue in terms of leaving it there is that when somebody does a complaint, they can do it two ways. They can go to the PSIC, or they can go internally to through the senior official that's been delegated and various people. Given that we're talking about political interference, this could put the head of a department in a conflict of interest in that ministers as well as exempt staff could be investigated by departments in that regards. Hence the rationale for taking it out. In terms of the specific question mentioned by Mr. Fergus, it would actually, if it is a bit of an additional issue as opposed to making sure that from a definitional point of view. But the way that it is inserted in the current bill, this is what would be the consequences of leaving it in that particular section of the PMB. Want to add anything?
Did you have anything to add, Ms. Stevens? You don't have to.
Just that for disclosures that are made within departments, it would require the senior officer to investigate, and to investigate a political interference. I think it blurs the line between the public service and the political level, which I'm not sure that we want to go down that road. Thank you.
Thanks, Mr. Garon.
Écoutez,
Listen. The amendment under reference number 8922 completely withdraws the notion of political interference from the bill. I want to be clear about this, even to the Conservative Party. If we adopt this bill, this recommendation, then CPC 3 will be deleted. And because CPC 3 says we will define it through regulation, so I believe that it will weaken the strength of the bill. To me, that is a fact. And so there would be no definition of political interference, and there would be no legal framework for the government to define it. So we have a choice, either 8922 or CPC 3. So what I am saying is, let's ask the Liberal to withdraw 471 and 8922. I agree, and we can withdraw BQ1 and then we can adopt CPC 3. But I want political interference to be defined. If we keep 8922 and CPC 3, then we have simply undermined this bill. That's a fact.
C3 is not subject to any line issue. It's a standalone. If this goes away, CPC 3 does not get deleted. It will be a separate one that will be debated and voted upon. CPC, there was the first one that CPC 1 is subject to if G3 goes NDP 3 or 4, then it affects CPC 1. But CPC 3 is, there is no line conflict that stands alone.
Deux choses. D'abord, une question.
Two things. Firstly, a question. Can
Mr. Garan?
Parce qu'il me semble.
Well, with all due respect, maybe I misunderstood. But from what I understand, what you're saying, everything you have said was accurate until these last-minute amendments tabled by the Liberal Party. Because while we are...
I apologize. I thought you had said that if this motion changes, CPC 3 would be eliminated. And I'm just saying it will not. But I may have misinterpreted what you had said originally.
Non,
Go ahead.
non, je comprends.
Yes, I understand. But what I'm saying is, substantively, if we withdraw political interference from the bill, which is what 8922 does, then we would question the use of CPC 3 that aims to define political interference. So maybe, strictly speaking with the procedure, it doesn't kill CPC 3, but it creates some incoherence that is quite important.
Mr. Ferguson, Ms. Kusi?
It doesn't kill CPC 3. Indeed, it allows CPC 3 to establish what political interference is, and it replaces what was in the private member's bill. It will allow it to be done, and in a way that makes it consistent. I hope that's the correct understanding. I don't know if perhaps our legal folks can give us a sense of that, but I just want to reassure Mr. Garon, it does not eviscerate CPC 3. It actually is giving definition to a new clause 4 here.
I mean, legislative, not illegal. Technically, because CPC 3 hasn't been moved yet, it is all still confidential, so we really can't be discussing it as such.
Forgive me, Mr. Chair, but you had also mentioned that if one is adopted, it has consequential effects.
Well, I'm just talking about the numbers being adopted. I'm not talking substantively about any of the information included inside the amendments. All I've said is the numbers. But anyone watching is not going to know what the number relates to, as opposed to the actual. As opposed to the actual amendments. Are we ready for the question, or? Was there any movement, Mr. Garan, or shall we call the question? Okay, let's call the question on BQ1. Shall BQ1 carry? Clerk will do the vote.
Thank you, sir. Okay, on BQ1, Mr. Fergus. No. Mr. Baines.
No.
Mr. Housefather.
No.
Mr. Jawari.
No.
Ms. Thompson.
No.
Mr. Barrett.
Juste, je m'excuse, appel au règlement.
Call to orders, please. Microphone, please. Apologies, Chair. I thought I had withdrawn BQ1.
Motion to withdraw it. Do we have that then? Yes. Okay. Okay. We have unanimous consent to withdraw it instead. another 25 hours and we'll be done. Clause 2. The next up is G1, amendment from the government. I understand Mr. Ferguson. This is the second time now I've called you Mr. Ferguson, so maybe if we went to you last, I wouldn't mistake your names how often. Mr. Fergus, go ahead, please.
No skin off my teeth, Mr. Chair. I think we should support this piece of this amendment and this clause. It allows us to, and I hope that we have agreement with my colleagues as I've had conversations with Mr. Garon and others. The threshold in the current law is too high. And to remove any threshold would be, I think, too much. I think this is a juste milieu, that it's not dependent upon any independent officer. It's dependent upon the person who's placing the complaint or revealing or whistleblowing. If they reasonably believe that this is true, on the basis of a reasonable belief they are bringing this forward, I think that allows us, and it reflects what we heard at testimony as well.
Just quickly, colleagues, if G1 passes, we get into line conflict. So if it is adopted, NDP 1 cannot be moved due to a line conflict, as they both modify line 2 on page 2. Mr. Johns?
So we heard around the reasonable belief part that it was opposed by the experts that we heard from, and it's not present in any of the best practices in legislation that we looked at, when we look at whistleblowing legislation, and that it's so this is where we're at. We don't believe that this is necessary to move this. I think it's I don't believe that the reasonable belief is there, and we heard from experts that that having this removed shows that it doesn't actually increase complaints. That's what we heard from the experts.
Mr. Fergus? And then Mr. Housefather.
We heard from Tom Devine from the Government Accountability Project in response to a question that I'd asked him as to whether or not the reasonable belief test is one that is accepted. He answered that it was not only accepted, it was universally accepted. It's a legitimate merits test for whether or not whistleblowing disclosure deserves to be protected. And the best part of it, once again, is that it's not being determined by some higher up. It's being determined that the reasonable belief is set by the person who is actually blowing the whistle.
Mr. Housefather?
Thank you, Mr. Chair. I just wanted to remind my friend Mr. Johns that the reasonable belief test is actually what was recommended by the mighty OGGO in its 2017 report on page 95 in recommendation 1E. That was exactly what OGGO recommended. Thanks.
Ms. Vignola?
On est tout à fait d'accord.
We completely agree with this proposed amendment because it was a proposal, a recommendation made by the extraordinary OGGO, but it's also a recommendation from witnesses, and this is an internationally accepted standard, so there's no conflict in our opinion with respect to this amendment.
Perfect. Shall G1 carry? On division, colleagues? On division. And that, by the way, as I mentioned, wipes out NDP 1. We now go to Liberal 1 from the ones that were dropped today. Mr. Chouari, is that yourself?
Actually, I'm going to ask, if possible, Mr. Fergus to talk on that. Because I'm not...
Because we don't have it numbered like the others. It's reference 124. 30471.
124. Where is that? I don't. 37.
They weren't necessarily distributed in order, colleagues. That's why I'm reading out the number to you. It's number 124-30471.
Okay, thank you.
That's the one under May 15th, Mr. Jawari.
Yep. I'll move that the bill C-290 in Clause 3 be amended by adding, after line 2 on page 2, the following, colon 2.1 paragraph C of the definition protected disclosure in subsection 2.1 of the Act is replaced by the following. C, in the course of the procedure established under any other Act of Parliament, including the Conflict of Interest Act, comma, or semicolon.
Ms. Jawari, then Mr. Fergus. I apologize, Ms. Vignola, then Mr. Fergus.
Donc, très
Very quickly. The law as it stands now, with respect to subsection C, talks about in the course of a procedure under a federal law. And now the proposal of the Liberal Party, it includes the Conflict of Interest Acts. And when I look at the Conflict of Interest Acts, I see that protected disclosure is not referenced there. So I have a problem with an act that doesn't make any reference to disclosure, whether it's protected or not. So I think this recommendation should be dropped. This amendment should be dropped.
Madam Chair, puis Madame Vignola a tout à fait raison. L'idée.
Yes, my honorable colleague is absolutely right. We had discussions here that we added this just to clarify our discussions, but if members do not agree with it, we can drop it. This was just to help people understand that this would be implemented under such an act.
C'est la volonté du comité.
Mr. Fergus is offering to drop. We have UC for him to withdraw. Thanks, colleagues. Next one up. Oh, Mr. Fergus, I believe, again. It's G2, which is page 4 of the package, the original package.
To members, et puis si c'est acceptable à mes chers collègues, Monsieur.
If it's acceptable to my honorable colleagues, Mr. Chairman, I would recommend to withdraw this in favor of BQ2.
We'll assume that you just don't move it, and we'll go right to the next, which is BQ2. Thanks, Mr. Fergus. So we're on BQ2 now, colleagues, which is page 5. Is that Ms. Vignola or Mr. Guérin?
Je vais y aller.
I'll go ahead. We're simply requesting that lines 3 to 10, or lines 3 to 9 in English, be deleted simply because it's not very clear. Those lines were requiring royal assent in this bill. This is, and it's not possible with a private member's bill. This is why we were requesting that we delete lines 3 to 9, page 2, and that I think that is the same reason why the Liberal Party had proposed the same amendment. Thank you.
Thank you, Ms. Vignola. Again, like previous one, if BQ2 passes, NDP2 cannot be moved due to a line conflict. They're both modifying line 7 on page 2. Shall BQ2 carry on division, colleagues? On division. Wonderful. Excuse me one moment. Thanks, colleagues. We're now on G3, which is page 7 of the package. Is that yourself, Mr. Fergus?
This is, it's almost, it's just really setting out the entire framework in terms of what reprisal means and what would be, what would be considered to be reprisal, and it's consistent also with some of the changes that we made in BQ2 in terms of what is a reasonable belief, and it's allowing us to make it consistent throughout that section.
Right. Mr. Fergus, thank you. Colleagues, if G3 is adopted, NDP 3, NDP 4, and CPC 1 cannot be moved due to line conflicts. Mr. Garon?
C'est un bon amendement.
Yes, it's a good amendment. It clearly defines the definition of reprisal as we had it in mind. I am, however, rather sad. I'm an emotional person because there were some good elements in NDP 4. So maybe the government, Mr. Fergus, could do a sort of friendly amendment. So can we have a friendly amendment to add NDP 3 under page 9? That is before subsection A.
For the committee, so someone else, perhaps someone sitting very close to your left, might be able to fulfill such a role.
C'est parce que je vous regardais, Monsieur le Président.
Vous l'avez ébloui. Donc,
so the proposed friendly amendment is that before paragraph A, we should add the amendment NDP 3. That is, a servant who made a protected disclosure has refused to commit a wrongdoing or has cooperated. So we should include NDP 3 in your amendment, and we will add C2 to C and C6. The ones that are found under NDP 4. So we would incorporate the proposed amendments of NDP. We would incorporate those in the government's amendment, which would enhance clarity with respect to reprisal and whom it's targeting, without necessarily outrageously broadening the scope of the bill or requiring royal assent. So that is the argument that we have in respect to this friendly amendment. Reprisal, we know that witnesses have talked extensively about suffering from reprisals that they have suffered, all types of reprisals. The word that comes to mind is horror stories, because nobody wants to experience what they have experienced. And clearly defining this term will help eliminate any risk of somebody finding a loophole in this law and this act to be able to do reprisal on a witness. This is why we are proposing this friendly amendment. Two things. You're proposing that NDP 3 should be incorporated. I have no problem incorporating that in the amendment that government has proposed. Now, with NDP 4, I have a question to my honorable colleagues, because on the one hand, everything under C.2, C.3, C4, C5, and C6 is already covered in the law as it stands, or in the act as it stands. Now, if we include the wording of NDP, I feel as if we will limit the scope of the actions that it covers. So I don't think that was their purpose or their goal, far from it. This is why I think that, yes, NDP 3, but NDP 4, because we are making a list, we might reduce the scope of the act, and I don't think we should adopt this methodology because it's already found in paragraph D of PSDP, that is the Public Service Divulgation Act.
Mr. Johns, are you answering, or Ms. Vignola? Ms. Vignola?
Wanna go? Okay. Moi, je la voyais, je comprends votre...
Yes, I understand what you're saying, but I saw this list as being so broad that it will prevent cracks or loopholes. But maybe Mr. Johns could clarify the thinking behind.
I think I had Mr. Garon, then Mr. Johns. Did you want to pass over to Mr. Johns, Mr. Garon, or are you going to go first?
Très rapidement, parce que...
Very quickly, because we were looking the act as it stands right now, and there is a definition with respect to reprisal. It indicates any disciplinary sanction or retrogression of a civil servant, whether it's from the RCMP, their firing, or their dismissal, anything affecting their working conditions, or any action in this regard. I think that G3 and what we intend to add with respect to what NDP has proposed will come to enrich this section of the law.
Mr. Johns, then Mr. Purkis.
So I think the goal is to expand the list of actions that constitute a reprisal, including psychological injury. So we heard from experts that reprisals are more often manifested as psychological assault, and the infliction of emotional distress is more stealthy and harder to catch and litigate than traditional forms of reprisals like firing and demotion. And we also heard from witnesses who experienced severe psychological distress and lifelong psychological conditions resulting from it. So certainly these need to be considered in the reprisal. So this gives, I think, a better definition, and it broadens it. So it just basically expands the list, is what we're looking to do.
Thanks, Mr. Johns. Mr. Purkis?
Et merci beaucoup, Monsieur Johns, pour ça. Puis...
Thank you very much, Mr. Johns, for that. It's good to make a list, but sometimes when we make a list, we give the impression that we're limiting the scope of things. I might have a question to the experts later on, but in the current act, on page 3, paragraph D, we talk about any measure affecting their job or their working conditions. I think that the door is wide open.
That adversely affects the employment or working conditions of the public servant. Alors, j'aimerais juste...
So my question is this to Ms. LaRoche or Ms. Stevens. Could you clarify if the amendment tabled by NDP, that is the list, will it limit the scope of the act, or is it already covered by the act, the existing act?
Merci beaucoup pour la question.
Thank you very much for the question. I'm looking at the two acts in parallel because, and I have to agree with Honorable Fergus that Section D is quite broad when we talk about any measure that would affect the working conditions. It can be well-being, physical or emotional. Now, the question about if the list would limit it or expand it, it would really depend on the interpretation by the courts or the commissioner later on down the road. So it's a bit of the two. I really don't have, unfortunately, a better answer, but I think that the definition as it stands right now is quite broad. Do you have something to add, colleague?
Just that it may be that what could be missing from the NDP amendment is that similar type of catch-all as you have in sub D in the current act. So by giving a list with no catch-all, it is more restrained than what is currently in the act.
Thanks. Ms. Vignola.
Donc, si je comprends bien, mesdames,
So, ladies, if I understand you properly, if we keep D, because NDP doesn't want to delete D, so if we preserve D and we add clarifications under C, are you saying that we would be limiting the scope of the bill regardless of the fact that all corners have been covered? Because we know that any measure affecting their working conditions or their job does not in any way affect mental reprisal, because it could be looking at psychological reprisal here. Measures affecting their job, we would generally talk about their duties, we would talk about materials, and not necessarily the intellectual capacities to carry out a job, and that can be reduced because of psychological reprisal against someone. This is the reason why I think it's important to add emotional distress in this list. And anything affecting the family is not covered by this bill. And we all know, as parents and grandparents, when we have a child who is sick and who is bullied in school, when something happens to our child or our grandchild, we cannot focus at work. And when that reprisal is done by someone who should be our employer, who should be fair, and when we see someone whose children is suffering from bullying and threats, then that affects emotional distress. And this clarification is covered under NDP 4. This is what I see in C2 and 2C6. I don't see them as restrictive. I see them rather as broadening things. It includes all of this and more. This is what I read when I see these amendments under these clauses.
Est-ce que je peux répondre?
Please go ahead.
OK, merci. Merci pour vos...
Thank you for your comments. I would say that under subsection D, when we talk about working conditions, we talk about physical conditions and well-being at work, so emotional conditions. So the employer has to make sure that the employer is treated properly in such a manner that they are physically and emotionally healthy. And when you're talking about things that go on beyond the workplace, it's not under the purview of the employer, but they have to, of course, be empathetical to what is happening in their employer's private life. But maybe a compromise would be to take D and add examples that can lay emphasis on some conditions that are important for the committee. We might think about how to proceed, but that could give some emphasis on the psychological aspect of things and the other elements that you consider as important.
Mr. Fergus?
Wouldn't mind, perhaps she would add something along the lines to work that in, but say including but not limited to.
Your microphone, Madame.
Et l'énumération du NPD. Ça irait, ça?
Good.
Nothing else, colleagues? Great. I'm going to, Ms. Kusi?
My apologies, Chair. I just wanted to perhaps ask Mr. Fergus why the government did not want termination of contract to be considered a reprisal. Why you did not want termination of, am I hearing an echo? Termination of contract to be considered a reprisal.
The answer is likely that.
I'm trying to find your reference. Okay, I didn't say that, right? Oh, okay.
Are you comfortable with it, Ms. Kusi? Or did you want to respond to that, Mr. Fergus?
It's fine. I think it's, logically it's satisfied. Thank you.
Okay. Colleagues, if there's no one else, I'm going to just suspend real quick for one of our legis assistants to go over to Ms. Vignola to get all the details of the amendment, and then we will come back, we'll read it in, and then we'll vote on that. We're fine, colleagues? We'll suspend for a few seconds. Appreciate your patience. Our legislative clerks, who we've called our law clerks and our ledge assistants, Ms. Sauvé is going to read back for the record what the amendment is. It has been emailed out to you. Because we're combining, it looks like 3 and 4 with G3, eventually a lot of the Clause A, Clause B, et cetera, will be very different, but that will be corrected in the record. So for the sake of time, we'll just read the new amendment and then agree on it and move on, I hope.
So what has been circulated, just to clarify, Mr. Chair, so what has been circulated was the text of the sub-amendment that was proposed by Madame Vignola. Would you propose that I read the sub-amendment or the new G3 as it would read with the sub-amendment included in it? What G3 would sound like. All right. I'll start in the English. So that Bill C-290 in Clause 3 be amended by replacing lines 10 to 31 on page 2 with the following. Paragraph 4, the definition of reprisal in subsection 2.1 of the Act is replaced by the following. Reprisal means any listed measure taken against a public servant because the public servant, we would have a new A, which corresponds with NDP 3, has refused to commit a wrongdoing. And then we go back, so A becomes B, has made a protected disclosure, et cetera, et cetera. So far, so good? Pour la deuxième partie,
For the second part, which would be paragraph 2.1 of the same law would be amended as follows. A would remain the same, B will remain the same, and C would remain the same. And then under D, it would be any measure affecting their employment or work, not limiting the mandatory assignment or deployment of the public servant, any form of reprimand. D.4, any form of discrimination. D.5, the infliction of emotional distress. D.6, any act or omission that causes any psychological injury to the public servant. And then the rest unchanged.
So the sub-amendment on division, colleagues? Yep. Right. And so on division, and shall G3 carry as amended? Yes. On division, colleagues? Wonderful. Thank you very much. Clause 3. Shall Clause 3 carry? No, Clause 3 is just on its own. On division, colleagues? There was no amendments.
Yes, the Clause 3 as amended. Yep, Clause 3.
Sorry, colleagues, it's Clause 3 as amended. I apologize. On division, wonderful. Clause 4, we start with CPC 2. We're going to be here till 5:58, colleagues, because we started at 3:58. So hopefully we can at least get this through. So CPC 2, Ms. QC.
Thank you, Chair. We will be withdrawing CPC 2.
Well, if you're not tabling it, we don't have to withdraw it. So we're on to BQ3 then, which is page 13 of the package.
Ben, dans le fond,
Well, this amendment requests that in Clause 4 be amended by replacing line 34 on page 2 with the following. B.1, a case of abuse of authority within the meaning of subsection 2.4 of the Public Service Employment Act. So here we are defining what is abuse of authority, and we make reference to an existing law, so there is no double definition at this level. And there should be no major problem here because the definition already exists in an act, and that definition has already received a broad consensus in its implementation. So we just want to clarify that point under Clause 4B1.
Mr. Fergus?
So again, I appreciate the intention of BQ3. If it had been up to me having a choice between BQ3 and CPC2, which has not been presented, I would have chosen CPC2 because I think it accomplished the same thing, but it allowed just for some further definitions that could be done by officials to making sure that they spell out the process. So it's a bit of a surprise. They both speak to the same issue. They're both very, pretty clear, but I would have gone more to CPC2. So I'm wondering, since we don't have CPC2 available, is it possible then we could add a little bit, because I'm afraid if we could add just some further definition that could be done by officials, because I'm afraid there's going to be a lot of overlap here with the Public Employees Service Act. I think there could be some things which might not work. They're almost equal, but I think it requires some further definition, which is what the advantage of CPC2 had.
Me permettez-vous? Pardon.
If I may. Thank you. I'm trying to understand. Earlier on, we were trying to avoid too many definitions within a law, and now we are making direct reference to a definition that exists, that already has consensus, and now you want the civil service to define by regulation what is abuse of authority. Meanwhile, that definition already exists. I'm trying to understand the logic. With all due respect. Mr. Chairman, can I ask a question to our experts here? Do we have a definition under the Public Service Employment Act with respect to abuse of authority, and under which circumstance is it considered? Do we have a definition? Well, I don't have the definition before me, but I know that that definition covers recruitment and anything regarding staffing. So that is a more restrictive definition. Implementing that restrictive definition in a broader sense could have some things that are lacking and could be interpreted to be making reference to staffing. So that's the nuance here with respect to the definition under the Public Service Employment Act.
En fait, lorsque je regarde,
well, when I look at the definition under the Act, it is rather broad, but it says abuse of authority. It is defined that for this law, we would define abuse of authority as bad faith and personal favoritism. Yes, that can be implemented to the recruitment of someone, but it is under the framework of general definitions, and it can be implemented in a general manner as well. It does not, with all due respect, specify that it's in the framework of recruitment. It is under general definitions. This is why we used that definition.
Ms. LaRoche or Ms. Stevens, do you have a comment on that?
Just from a very technical standpoint, it isn't a definition in the Public Service Employment Act. It's called a reference, which says for greater certainty. It includes bad faith and personal favoritism, so it doesn't actually, as a whole, define the term. It's telling you part of what's included, but not the entire thing.
Yeah, please go
More
ahead.
for the purposes of hiring, so not to show favoritism in hiring public service employees in its current form.
That's how the term is used in the Public Service Employment Act, correct?
Je pense que Madame Vignola.
Ms. Vignola, if I may, Mr. Chairman, Madam Vignola, I think what you want to see as definition is something broader that will cover a wide range of situations that may not be possible in the existing Public Service Employment Act. So maybe our legal experts can give us an interpretation, Mr. Chairman?
Ms. Vignola?
Moi, je continue de lire.
I am reading the law concerning the Public Service Employment Act. It's not only about recruitment when we talk about abuse of authority in this law. Article 65, Clause 65 talks about abuse of, or rather secondment. And we're not talking here about employability. It's quite different. And we talk about motive of complaint, abuse of authority from the Commission's abuse of authority with respect to the appointment process. Yes, in this regard, we are entering into employment and hiring. But the law in itself is broader than simply the recruitment of someone. That being said, we can vote and decide through a vote. Maybe we can vote and the vote will help us make a decision. And if we need to reintroduce something else later on, we will. But the definition on the Public Service Employment Act is quite broad already. So I would propose that we move on to a vote. I would move for a vote and then make a decision afterwards.
Kusi?
Yes, Chair, thank you. After hearing Mr. Fergus's support of CPC 2, as well as the definition as clarified by Ms. Stevens, and in consultation with Monsieur Guérin, I think I will be asking for unanimous consent to add once again the amendment of CPC 2, as it seems to satisfy the concerns as voiced support by the government and perhaps addresses the concern as outlined by Ms. Stevens, which I believe Madame Vignola has concern over as well. So I'm asking for unanimous consent to reinsert CPC 2, please.
Just one moment. We'd have to withdraw that one and then. Thanks, Ms. Kusi. We have two options. Ms. Vignola, if you agree, we could do a UC to withdraw yours, and then we can go to that. Unanimous consent to withdraw. Great. So we're back to CPC 2. We're on. Wonderful. Colleagues, we only have like 3 minutes, so I'll let... Sorry, CPC 2 on division. Sorry, I thought we agreed on division.
Yes.
Perfect.
Okay. Congratulations.
Yeah, I'll go to Ms. Block, but I'm just going to suggest that we just adjourn for the day and take this back up on Wednesday. We will be in room 410, which has limited space, so please keep that in mind before we invite such a large involved crowd. So just be advised of that. We have Ms. Block, then Mr. Barrett, then Ms. Vignola.
Thank you very much, Mr. Chair, and I want to thank you for shepherding us through the very few amendments that we've managed to get through today. I also want to, I guess, register formally my frustration in having 12 amendments table dropped just 1/2 hour before committee, especially given the extension of 10 days to submit them to the clerk. I would suggest that going forward, any sub-amendments should be brought to committee ready to provide to members, that we work ahead in preparation for the rest of the amendments that we're going to be dealing with, that if there are sub-amendments that we want to propose, we speak to our colleagues ahead of time, come prepared, and that perhaps a new package of the amendments be tabled or sent to us with the ones that were tabled today. I think that would help us with some of the confusion that this created.
Our legislative clerks would like to respond.
Yes, just to confirm, there wasn't enough time to update the package, but with the 12 amendments that were received today, we will include them in the package, and we'll send a new version of the package and of the agenda for next meeting.
Perfect. Thank you so much.
You're welcome.
Mr. Barrett, then Ms. Vignola.
Thanks, Chair.
Mr. Fergus.
Just for the business of the committee, I'm supremely confident or maybe optimistic that we can move through this during our scheduled 2 hours and our next regular meeting. We have a need to hear from department officials on the production of documents related to a different study. And I'm just wondering if the plan is for that to be scheduled during regular committee time on the Monday following the return from our constituency week, so 2 weeks from today, or if that's going to be extra innings this week, and just so that there's an understanding and an agreement in principle in this room that we're going to get to that, which maybe will help us focus our minds to achieve that optimistic outcome that I think we're all hoping for on Wednesday's meeting with respect to moving through clause by clause on this.
Great. Yes, that is a priority for myself. It will be next Monday, Wednesday. We will do week be June 5th and 7th, sorry, a week from, or 2 weeks from now. We will do the departments. A lot of them have already responded. We did have some time possibly for Wednesday, but the way things have been going and lack of resources and cancellations, so I've decided not to go ahead with added for this Wednesday for 6:30 to 8:30. So we'll be the first Monday back, or
the 29th, Chair?
29th, sorry.
29th,
June 5th and 7th. The 29th is PSPC for the estimates. 31st is Treasury Board on the estimates. 29th, we're voting on the estimates mains. Sorry, June 5 and 7th. Getting my calendars mixed up. But yes, 5 and 7 in our regular allotted 2 hour period, 3:30 and then 4:30 for the departments. And Ms. Vignola, thank you for bringing that up, Mr. Barrett. Ms. Vignola, then Mr. Fergus.
Ça va être simplement.
Very briefly, at the beginning of this meeting, we had agreed that CPC 3 would be adopted if we put aside BQ1. So I would like for us to adopt that, close CPC 3, close that circle, and start afresh during the next meeting on Wednesday. So let's conclude with what we had agreed upon at the beginning of this meeting, that is adopting CPC 3.
Why don't we just get Mr. Fergus first, and then we'll come back and discuss that quickly?
Effectivement, Monsieur le Président.
Well, Mr. Chairman, that was actually my proposal. If we can start afresh next time, because we don't want to give extra work or work that is not relevant to our legal experts and our analysts, so that we are sure that the submissions are properly numbered for next time. That's it.
So, shall CPC 3 carry then, colleagues? On division? A wonderful suggestion, Ms. Vinola, and thank you, Mr. Fergus. And thank you, colleagues. Slow start, but we actually made through a bunch. There's not quite as much in the last several pages, so hopefully we can finish it up Wednesday. If there's nothing else, colleagues, we will adjourn. Thank you very much.